Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class, and tonight we're going to be continuing our reading of the document entitled U.S.A, the Republic That No One Lives In, and this will be the last installment for this series. And we left off at page 46 with the Constitution, and if you'd like to join the Vocational Science Freedom Gilded server, you can do so by going to the Vocational Science Freedom YouTube page and clicking on the banner in the upper right hand corner at the VSOF Gilded server, and then you'll be prompted to answer some questions when you get to the server. And I highly suggest that you download the application and run it, and up here in the upper left hand corner there'll be a little apply and a little follow. Make sure you hit apply, and that'll get you in. So let's get going here. So we left off at page 46 with the Constitution. So the Constitution, as a political document, the U.S. Constitution is little read and poorly understood. Yet it outlines the incredible ways that a truly free people can obtain and retain liberty. Unless certain aspects of its structure and meaning are understood, it will be impossible to realize the true genius of the document as it reveals the pure principles of liberty. The Constitution embraces two systems of law. First, public municipal law for private purposes operating in personam, in and for the individual person. Second, private law for public purposes operating in rem. The definition of in rem means an action against a thing. Okay, so that's what in rem means. In and for property or anything that has nothing to do with the individual. So what is hard to initially understand is that the men who wrote this document wrote it in such a way that it would allow for the very things that government is doing today that we detest so much. All of the despicable regulations and interference of Big Brother with his detest heavy-handed tactics are all properly allowed by our Constitution. They are perfectly legal. This is because the United States government is allowed to operate outside the Constitution because it is operating in private Roman civil law. It is not treasonous for it to carry on the way it does, but it is treasonous that the citizenry are ignorant of their republican rights that can keep the government in check by removing the Roman civil law. And of course, the Roman civil law aspect of it is all contractual. It's all by your consent. Because as Jefferson once wisely said, the just powers of government are derived by the consent of the governed. So if you do not consent to the Roman civil law, statutes, acts, ordinances, and codes, they do not apply to you. But as we know, the trouble is that it's about the registry, the registration of property that ends up putting us and our property into this Roman civil law system. So to continue here. Of the two systems of law that the Constitution embraces, the entire population have been herded over the years into operating only in the private, unilateral, contractual side. This is the side where we have volunteered unknowingly into giving up the part of the Constitution that was designed to keep the private law out of public policy, if used, accessed and maintained by the people. What is unfortunate is that the citizen continues to assume that voting is making their desires known and that the government basically has the interest of the individual in mind. All the time unaware that private corporate business interest is what the government is there for at this point, because the House of the Republic of the United States of America, ignorantly vacant, remains empty. And to pause and make a note here, the reason it's been empty, or at the time when it did become empty, is when, after the Civil War, during Reconstruction, when Lincoln ordered the Southern delegates to come back to Congress, and they said, no, go to hell. And basically from that point on, Congress, as far as the Republic is concerned, the Republican Congress has been seen die, which means without a day, since that time. And that's when the military law under the Lieber Code and all of the regulations that came with it and everything that was done during all of the Reconstruction Acts is when they turned everything fully into this corporate system, where then it was enacted and started with the District of Columbia Act, and I believe that was 1871, if I'm correct. And then they moved everything into this corporate situation that then was there to administer everyone basically through martial law, through military law. So that was the last time that the Congress was properly convened under the Republic, with all of the protections that everyone should have under the entire Bill of Rights. So to continue here, Table 3 is an attempt to contrast the two sides of the Constitution and how you are affected by them when you are operating in that particular area, either left or right. The statements are intended to be self-explanatory. This table may form the basis of seminar discussions on moving yourself back into the Republic. So, Constitution of the United States of America, Constitution of each state, general common law. The two sides of the Constitution. Left side, we have political constitution. Right side, we have economic constitution. So, left side, statutes at large, positive law. Right side, code pleading, non-positive law. So, code pleading is the aspect of Roman civil law. This is thou shalt not because I say so. Positive law aspect is that it causes a harm. So anything that is written down that actually has a harm related to it. And there's only 4 things that the federal government, technically, under the Constitution, can actually charge someone with and go after as far as a crime is concerned. And no, it has nothing to do with marijuana. No, it has nothing to do with drug charges or even murder. All of that is supposed to have stayed under the common law. And the only 4 things that they have the capacity to do are indict for piracy, indict for any violation of the law of nations, or basically treaty violations, treason, which is the only thing that's actually defined in the Constitution, and then counterfeiting. That's it. That's all that they have. That's all that was ever given to them. Everything else was always supposed to have been adjudicated through common law courts of record, firstly by indictment by a grand jury of 25 members of the peerage that then would bring an indictment, and then it would then be adjudicated or prosecuted, is the better term when it comes to something of a criminal nature, would then be prosecuted by whoever the sovereign was who had the damage, harm, loss, or injury done to them. Now, you can also do it from a standpoint that the foreman of the grand jury can also prosecute the case themselves if they wish to, which has been done in American jurisprudence many times. And so you could go that route, or you could hire, if you wish to, meaning the grand jury, you as the grand jury could hire a special prosecutor. And you hear that term a lot in federal law. Oh, we're going to get a special prosecutor to go do this, that, or the next thing. Well, you can do the same thing under common law if you want to. So anyway, back to this back and forth here. So the left-hand side, you have the full protection of the Bill of Rights. The economic constitution is only amendments 11 through 25. On the right side, this is in law. This means de jure, basically in jure or in law by right, meaning that when you're the in law side, you're actually decreeing the law in the courts of record on this side of things. Okay. This side, Article 3 courts of judicial power in law and equity. This side, Article 1 courts, also territorial courts, referred to as legislative or ecclesiastical courts. This is your Roman civil law, maritime amnesty garbage over here. These are your at law and equity. And the only time that you would really be dealing with equity in this side correctly would be if it were some sort of a violation of a contract. Like somebody didn't uphold their end of the bargain of some written contract. That's where equity would come in. So this side is the law of the land, this side is the law of the sea. Even though technically under the actual Constitution, the federal government does have jurisdiction over maritime amnesty issues, that's fine. But what they've done is they've pulled everybody over here into the corporate side of the maritime amnesty for banks and banking issues, wherein you have all this registration, you have birth certificates that get registered and then bounced through all of the various different government agencies, like the Department of Commerce and Education and all of these other agencies that they set up basically after the New Deal that take part of the productive value of your estate and try to make money off of it, which is pretty much what they're doing on this side. Okay, so this side again, negotiable instrument law, all debt must be paid. This is an aspect of gold and silver is money. This side, limited liability for maritime venture and payment of debt. This is your Federal Reserve note. I'll pay you sometime later by giving you a promise to pay. It's a promissory note is what a Federal Reserve note is. So it's always tomorrow. Nothing's ever settled on this side. I'll pay you later, I'll pay you later, I'll pay you tomorrow. This side, you have to pay your debt from the standpoint of actually gold and silver. This side, statutes are public municipal law to be used for private purposes, acts in person, in personam. These are revised statutes, are private national law for public purposes, in rem, actions, again, against a res or a thing, which is what they create whenever you have even so much as a traffic ticket. What they're doing is they're creating a constructive trust out of the court case, and then what they're doing is they're administering your res or your stuff from your estate in that constructive trust and in that court case. And of course, as we know, all of these private for-profit courts all have their own Dun and Bradstreet numbers. So they're not even constitutional courts. They've gone so far as to just simply being corporations. And I posted some stuff in the main chat yesterday. I posted a video of Judge Joe Brown going off on a talking head about how these courts are not constitutional, and what they're doing opens them up to liability. And the main reason is because that these private for-profit courts hold separate purses from the state. So usually, I mean, if they were doing things on this side and you tried to sue them, they could take 11th Amendment immunity and say, well, you can't sue the state because of what we're doing, because we're acting within our good behavior, if you will, staying inside the box of the Constitution. Well, that no longer applies because they have separate purses. Their money is not connected to state funds. So they are separate corporations that can completely be sued out of existence. And that's what I highly suggest people start focusing on, is the fact that, yes, you can sue the courts because they have no 11th Amendment immunity. And if anybody has an issue with that, I have 3 cases that TJ gave me that clearly lay out, that actually a federal judge gave him in a specific case that he was involved in. And how the story goes, or how TJ tells it, is that the federal judge had everybody come into court one day for what they thought was a motion hearing, and she named every single one of the defendants. Now, TJ was the one that was actually kind of prosecuting the case, and she named all the defendants, made them stand up in the courtroom, then asked if the prosecution, the plaintiff, was there, and TJ and whoever else it was that he was dealing with stood up. And then she said to all of them, I have these 3 cases, and I want all of you to, she said, I'm not going to listen to or hear one more motion from any of you until all of you brief out these 3 cases. And every single one of the cases was a case regarding the fact that these courts, which TJ and the other, I think it was a woman, were suing, do not have 11th Amendment immunity because they have separate purses from the state. So it's very important to understand that. And yes, you can, of course, throw their Dun and Bradstreet number in their face, but they don't care about that anymore. There was a time when you would actually get a reaction from these lower courts when you would bring in their Dun and Bradstreet number and be like, look, you're a corporation. How do you possibly have jurisdiction over me, right? Well, now they're so corrupt and so rampant, they're so full of criminality and hubris, basically, that they just don't give a flying fuck anymore. So what you have to do is just flat out sue them and say, nope, you never have jurisdiction over me. I don't have any contract with you. I don't have any legitimate contracts with the corporate state. And unless you produce evidence on the record that shows that I have somewhere along the line signed a legitimate contract, meaning one that actually had an exchange of lawful consideration intertwined with it, well, then I don't have anything to do with you. You have no jurisdiction over me because you can't even pull me into equity because there's nothing to adjudicate here. There's no consent to enter into these inferior jurisdictions, these territorial courts, if you will. So with that, it's an important, all of what I just said was an important thing to know. And if you want to just have a statement that you can say in court verbally, you can always state, Your Honor, and you can do this at any point in time, whether it be before arraignment or if they drag you in off the streets, whatever, it doesn't matter. You can say, Your Honor, I do not consent to be bound by any unrevealed contracts, trusts, pledges, bonds, or oaths. If you state that, Your Honor, I do not consent to be bound by any unrevealed contracts, trusts, pledges, bonds, or oaths, that then puts them in a very difficult position because it's all based on presumption that you have agreed somewhere in the past to be subject to this inferior court jurisdiction. So it's important to always state that. And it's also important to demand to be released from the jurisdiction because there's no consent for you to be there in the first place. And I could go on with that. There is a section of under U.S. Code of 18, the criminal title, under 18 U.S.C., where it specifically talks about that the defendant has to consent to the transfer of jurisdiction to these territorial courts. And you can bring that up too, particularly if you ever get into a situation where where you're trying to be charged with some sort of quasi-criminal action under federal law. That is definitely something that you need to pay attention to and definitely need to say. You can say it in brief if you need to, or say it in motion, but it's always good to just bring it up in open court as well. So, okay, so to continue here, down here we got de jure government inside Constitution. The other side is de facto government outside the Constitution. Here side we've got general law, I'd say common law, sustained by Swift versus Tyson. Here you've got local law, or local municipal Roman civil law would be the proper way to say that, sustained by Erie Railroad versus Tompkin. This is the case where the Supreme Court said, well, there is no more federal common law. Well, yeah, for the 51% of the democracy that decided to bind themselves to this side of the train, yeah. This side, you have the gold standard, public law, merchant uses no inflation, true productivity, prices at par value, and nothing ever keeps going up because obviously gold is gold. It's the same. And just to make a point on that, J. Edward Griffin makes a wonderful analogy in his books and in his speeches. He says that if you were to take an ounce of gold and go all the way back to Roman times, it would buy you a fine toga, a handmade belt, and a handmade pair of sandals. You take that same ounce of gold and you bring it today, forward to today, you could walk into any men's store and buy a fine suit, a handcrafted belt, and a handcrafted pair of shoes. So it never alters, it never devalues. But on this side, you've got the Uniform Commercial Code, UCC, private merchant use of inflation to fund growth, false production, no fixed standard. And this is the whole entire banking system. And if anybody wants, you can, because I'll have one more section of the playlist for the banks and banking. If you guys want, you can go to the Vocational Science Freedom on Odyssey and make sure to check out and watch all of the banking timeline classes that I did. It's How Bankers Stole the World, and it's a 9-part class, and I'll drop it in chat here real quick. And if you want to know the entire history of banking and how this all got started, that's the class that you want to go watch all the way through from start to finish. Okay, so this side, bilateral contracts, meaning meeting of the minds. There's two people. This side, you have unilateral implied contracts, also better known as pledges, which is why you want to say that you're not bound by any unrevealed pledge. So in this side, these unrevealed contracts and these unilateral implied contracts, this is what creates all of the presumptions. And there's some great documents, some great books written about this, and they're available in the Vocational Science Freedom VSOF online library. And one of them is The Pied Pipers of Babylon, which is an amazing book to read. And the other one is called Invisible Contracts. And both of those are available on the online library. And they're very important to understand what this kind of contract situation is and the problems with it. So moving down here on this side, Oh, okay. So that's basically what I was saying. It's an extension of the definition of what these are. So yeah, there's no meeting of the minds, two-party transaction, no compelled performance. That's a proper lawful bilateral contract. This side, this is where the silent third party involved in compelling performance, and this is an aspect of obviously trust law, because your whole entire estate is being administered, but it's broken up into various trusts. And so when you understand trust law, it gives you a tremendous power over them and what they're doing in the court system, because you can express the trust and say, look, I know what you're doing. This whole entire thing is a constructive trust. However, and put up your hand and be like, well, wait a second, you guys, you are administering the res of the stuff of my estate in that constructive trust. Now, I do not consent for you to administer any part of my estate. Because the important part to understand about trust law and probate law is that the estate comes first. Then the trust comes after. You cannot have a trust without first having an estate of which the res comes from, which is why it's so important to brush every single aspect of them administering the estate. And then you don't really have to worry so much about what they're doing on the trust law side. It automatically all becomes fraud. So on this side, you have common civil law, juris non scriptum. This side, you have Roman civil law, maritime amnesty, privilege, ecclesiastical church law, and I would also add over here the law merchant in general. This side, you have absolute rights and title to self and property, meaning allodial title. Substance of public law is the rights of man. Over here, you have relative rights to self and property. Substance of private law is the conscience of trust. This is where Roman civil law breaks the title into legal and equitable. So you have a legal title, which is the one that actually owns the thing, and then you have the equitable title, is the one that has the right to use the thing. And if you're the one that has the right to use it, meaning saying you have a certificate of title, say for your car, for example, then that shows that you have the right to use it, and then that makes you what's called a usufructuary. You only have the right to use, you do not own it, which is why the first thing the land pirate says to you when they put on their little flashy lights and come up to your window in their clown outfit is they say license and registration. Why is the registration important? Because they know by presumption that most likely the thing that you're riding around in has been registered at some point with the corporate state. So they want proof of that so that they know that they can tow it or even pull it over to begin with. And the presumption is that it is involved in commerce in some way, shape, or form, that you're using the roads and highways as a place of business, as either a for-hire carrier or contract carrier, and therefore are using the roads in a extraordinary way, not just for the right of travel, meaning from getting to point A to point B, but you're using it as a place of business, and then therefore they have the right to police you in that activity, which all falls underneath the Commerce Clause of the Federal Constitution. So without that, they don't have it. They don't have jurisdiction. And of course, the license part is, do you have a license to use the registered thing which you are presumed to be using in commerce? So to continue here, operates under Article 4, Section 4, no corruption of blood, cannot interfere with what? Cannot interfere with the estate. Over here, operates under Article 1, Section 8, can interfere with the estate under private implied contracts, or again, these trust relationships, or again, the idea of the pledging. That the mothers go to the foundling hospitals, because a foundling is a lost or abandoned infant of unknown parentage. They go to the foundling hospitals and they abandon their child by document through the birth certificate contract, and then that is the presumption that they use to say, well, no one has ever come back to claim the estate, and no one's ever presented a will of this infant. And how would you have a will of your own when you're a little bitty baby? You have no idea what's going on. You're just looking around and saying, ooh, look at that. So you have no will, and so therefore they end up administering your estate just in the same way that they used to under common law, but under English jurisprudence in what was called the Court of Wards and Liveries. And everyone knew back then, and this was, the Court of Wards and Liveries ran from about, it was like early 1500s to mid to late 1600s. It basically was kind of done when they did the second or no, not second, sorry, fourth Sesterke Vi Act of 1666. Then they kind of got rid of the Court of Wards and Liveries because they wanted to shift everything in England over to this private conscience trust garbage under Roman civil law. So they could consider everyone dead to the law because they burned London to the ground and say, well, you must all be dead. And if you don't come back and claim your estate, well, guess who gets to administer it for the rest of their lives? The crown. So same idea, same modus operandi. They just had to do it differently over here by a lot more years of boiling the frog, so to speak, and I'll just leave it at that. So over here, you're a non-14th Amendment. I don't like the word individual. It should say actually non-14th Amendment should say people, not individual, because the definition of individual is the same as infant. So let's fix that. So again, private, not individual, but private people. People here. So non-14th Amendment people. Over here, you're a 14th Amendment person. And remember, the definition of person under Title I, U.S.A, subsection 8 on a definition of person is defined as an infant, also known as a human being. So over here, you're private. Over here, you're individual considered commercial person or goods in commerce because the productive value of your estate is being administered for their profit through this monopoly system of the Federal Reserve and the IMF and the special drawing rights, but I don't want to get into all that. That's what happens on an international level when they trade citizens, if you will, or trade goods in commerce, which is why you have to have a passport to pass through their ports because you're nothing more than a commercial unit in commerce. That's why you have a passport. So anyway, for servicing the public debt, because that's what they're doing, they're saying, okay, you guys' productive value is going to service the public debt, even though, here's the deal, it's not our debt. It's only Congress's debt. That's it. Congress owes the debt, not us. It's always been their debt. It's never been ours because they're the ones that racked it up and bankrupted the Republic. Well, Lincoln more or less bankrupted the Republic in the Civil War, but it's never been fixed. And the Republic has never come back, as I said, because of the problems after Reconstruction. But also referred to as a state of human resource, right? This is why you're called a human resource. As like a piece of iron or copper or steel. You're a resource. You're just you're capital. Because that's actually what capitalism means. Cap, meaning capit, head. Capitalism is a system that derives a profit off of your head. That's what it is. It's not free trade, right? Capitalism is a system that derives a profit off of your head by everything that's in this right-hand column here. So this side, you have freedom of conscience of, again, I would say people, not individual, beholding to no one. Because over here, you're sovereign. Over here, the freedom of conscience, as long as it agrees with the majority of the masses, because you're stuck in the democracy. Over here, you have a democratic republic. I would say a constitutional republic would be a better way to say that, but okay, fine. You have a constitutional republic on this side, states in the Union. This side, you have an administrative democracy. Several states of the Union are also the conquered territories. This is after the Civil War when the southern states, well, basically, it wasn't just the southern states, but they basically considered all the states then conquered territories and put them back under territorial rule. On this side, you have the territory. This is a territory. This is separation of powers, separation of church and state, and obviously the three branches of government. This side, there's no separation of powers, no separation of church and state. And literally, on this side, the president of the corporation rules basically as a dictator, which you're clearly seeing more and more of with Biden's insanity. This side, there's no communal relationship. This side, Confederacy under Articles of Confederation and Northwest Ordinance. And I don't exactly know why he says that because that's not exactly correct. I mean, yes, over here you have no communal relationship unless only for the contracts, lawful contracts that you have entered into with other people. There's your communal relationship. And also your communal relationship over here too, another way to look at it would be 25-member grand juries of the peerage and 12-member petite juries of the peerage. That is your relationship to your society over here. So no communal relationship, that's not exactly true. And what he's getting at over here, Confederacy under Articles, Confederation, and Northwest Ordinance, these two documents are still in full force and effect, so I'm not exactly sure what he's getting at here, aside from the fact that they're operating under territorial law, meaning that the United States has the capacity to rule the territories. I guess maybe that might be what he's getting at here. So over here, direct taxes, I would say lawful taxes. Over here, you have indirect taxes, because you can have an indirect tax as long as it's apportioned. So what you can't have is a direct tax that's unapportioned, or an indirect tax that is apportioned. So you can't have. So what you have to have is. So a direct tax would be something from the standpoint of like the. Well, I'll put it this way. I'll do it the other direction because it's easier to understand this way. So an indirect tax is something like gas tax, or something like tax on cigarettes, or something like tax on alcohol, right? That's an indirect tax, because not everybody necessarily has to pay it if they don't drink, if they don't smoke, or if they ride their bike and don't own a car, say, right? So that's an indirect tax. So you can avoid indirect taxes by simply doing something else. You can grow your own tobacco. You can distill your own alcohol, or brew your own beer, or, brew your own wine. That's fine. You can get away from those indirect taxes. But if it's a direct tax, meaning everybody has to pay it, that means it has to be apportioned, meaning everybody must get the benefit from it. And if it's not apportioned, meaning if it only goes to, say, the IRS to pay the national debt, well, then that's a direct tax. It's unapportioned. You can't do that, right? So that's a better explanation than just putting these two up here. So over here, 15 statute at large is designed to keep federal courts from taking jurisdiction. Courts cannot take judicial notice of the 14th Amendment. This keeps you out of their democracy. Over here, all courts take jurisdiction through the 14th Amendment until one proves otherwise, meaning, objection, Your Honor, I am a de jure state citizen, meaning lowercase s state and capital C citizen. Or, Your Honor, objection, I'm one of the people of Texas, or whatever state you're lawfully domiciled in. Over here, codes are streamlined, private interpretation of statutes at large for public purpose. Codes allow the courts to take judicial notice of the 14th Amendment. Codes apply to anyone who has not made a public notice of his political choice, meaning your will by declaration, saying, fuck off, get off my estate, you have no business administering it. So, here you've got doctrine of complement, special individualism. Over here, unisex, no individualism, meaning you're part of the mob. Over here is basically what he's saying. Over here, innocent till proven guilty. Over here, you got Roman civil law. You're guilty until proven innocent. And the burden of proof rests with the accused. The burden over here, under the common law, always rests with the accuser. And you see this all the time, specifically with how they do arraignment. So you'll come in for arraignment, say a traffic ticket, and the judge will say, this charge and that charge and this charge and that charge. Do you understand the charges against you? Well, most people say, yeah. Well, if you do say yes and you agree to that, then you've just agreed to be subject to Roman civil law. If you say, no, Your Honor, I did not understand the charge, he'll repeat it or try and say, well, what do you not understand about it? You'd say everything, Your Honor, because I do not consent to be bound by any unrevealed contracts, trusts, pledges, bonds, or oaths. And furthermore, Your Honor, I do not accept any offers of contract from this private for-profit court. If you say that at least once and you stick to it, meaning you don't ever agree to a contract after that point, there really isn't a whole lot of holy fuck they can do about it. Because if they do continue to try and administer without it being, like specifically with there being no harm, like say, again, speeding ticket, something like that, or say marijuana possession, where you just owned it, it was your own thing, you're putting it in your body, fine, so be it, then there's no way they can move it into the common law because there's no damaged party. And there's a very important maxim of law that states that where truth exists, fiction of law cannot exist. And the importance of understanding that maxim is that when you are there present as one of the people, as the executor and heir of your estate, that you have documentation to stand on that you've placed onto the public record that proves the same, you are standing in truth. They cannot move you over to anything being in fiction. On this right-hand side over here, all this trust garbage, can't do that. And that's what we're pounding them on. We're doing it far better than anybody else is, I can guarantee you that. Because there's so many more things that we do from understanding how the system works and understanding what they're doing in their side of the system over here that we can beat them over the head with endlessly to get out of that jurisdiction. So over here, plead to the law or statute for defense. Law awards damages and equity on this side, compels performance of award. Over here, res judicata, judgments based on merits of case and legal precedents. Courts tell what the intent of the legislation is. So basically you have black-robed priests practicing law from the bench on this side because they're in ecclesiastical courts and they can do whatever the fuck they want. They don't have to file law. So the issue is already decided. You have no legal recourse. Now, they'll say you can appeal stuff, but it doesn't matter. They're never really going to overturn anything that the lower courts do if you're the one that agreed to the jurisdiction, you agreed to the contracts, and everything else that goes along with this ignorant side of situation. And yeah, by the way, that's an important point, Amora. I no longer call the special administrators, Your Honor, or it's better to just call them trustees and just say public trustee, or just say trustee, I wish for this, or trustee, I wish for that. And they're going to get mad about it, but who cares? That's what they are, particularly if you've done your VSOF doc set and they have no, and the black robe priest sitting up on the bench knows about it. Well, they have notice. They have notice that if they administer your estate, any part of it, they've agreed to be a trustee of your estate. And so then we force them into being your private servant on the private side of things, which is something that nobody else is doing. No one's doing that. No one's forcing them into a contract to control their ass by their movement, their decision, their performance. Because that's what they try and do with us all the time. They try and get us into all these contracts by performance. Oh, well, you went and did this. Oh, you got a driver's license. Oh, you went and decided to go get a license plate. La, 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 la. Well, that's all performance. Okay, what if we've said no? We have rescinded all contracts with the corporate state, which we do in the doc set. And then we turn and say, but wait, we have an offer of contract for you now. So you wipe the slate clean, literally, you wipe everything off the chalkboard. And you then start with the offer of contract and say, this is now the only valid contract. Now you could technically also say, look, the constitutions are also valid contracts. Where's your oath and bond? But as we found out, a lot of these bastards don't have oaths and bonds. Why? Because they're not operating under the Constitution anyway. So they don't have them. Well, that becomes kind of a problem because what would be the more, well, what people have done, let's put it this way, that was highly intelligent to do was actually to go and sue out the public officials' bonds for being outside of their oath to uphold and protect the Constitution when it dealt with someone like us, meaning we're out, we've made sure that we're not a 14th Amendment citizen, we have put down lawful documentation and declaration to state that you are, or that we are, only a de jure state citizen, one of the people, and everything else that's listed in the Vocational Science of Freedom Declaration of Nationality, which is a long laundry list, and I don't want to get into it. But it only states what we are. So once you do that and you've put it onto the public record, well, then guess what? They can't presume, they can't use the presumption to keep you over here in this aspect of trust law. And then you could go after their bond. But they're not even filing oaths and bonds anymore. They just don't give a shit. So anyway, this is just a continual degradation and destruction of the whole entire system. Okay, so back to this. On this side, fixed in a place and time at permanent domicile. I should just say permanent domicile because a residence is not permanent. That's what it should say. Fixed in a permanent place and time, permanent domicile. Real substance, matter, and content. Heart, soul, spirit. This side, crazy side, twilight zone. Quasi-law. No time and place. Only exists in abstract space. Artificial, abstract, false, and theoretical. Conscience. Changeable. Right? Again, this is the very important thing about that maxim of law that I said. Where truth exists, fiction of law may not exist. These things are like water and oil. You cannot mix these two. Over here, individual incentive and true production. Over here, no initiative and no true production because you're dealing with monopoly money. So here, okay, so that's the end of the chart. So from that, next section is political action groups. If you're trying to be involved in shaping public policy, you are trying to use private law for public purposes or private church law to manipulate public commercial policy. No one really wants to have a church or other individual, without the opinion of choice, dictate what he should think or do. Yet, what is happening with special interest groups is just that. Political action groups, also called special interest groups, i.e. environmental, health, labor, industrial associations, state, county, borough, city, coalitions, religious foundations, etc., are nothing more than individuals who have banded together because of a common belief in conscience. Their endeavor is to put pressure on lawmakers of the 14th Amendment Trust to pass laws that favor their beliefs. If they are successful, then the laws that result become the policy of the trust, meaning the 14th Amendment Trust, that bind the rest of the 14th Amendment Trust beneficiaries, the 14th Amendment citizen slaves, whether they like it or not. If they don't, then another special interest group is formed to try and counter the previous one, and so it goes ad nauseum. The politicians become the pawns of the most powerful special interest groups. The only way to change public policy is to prevent private law from having any part in making public policy, meaning private law of the Roman civil law side, making public policy. Public policy is only the administration of infants. Well, infants and corporations. So I wouldn't have a problem with public policy as long as it had law that was written down for corporations that they had to follow, right? You can't go, using a nuclear weapon to, say, blast down a whole entire forest at once and then go pick up the trees. Something, things like that, obviously. Can't have that happening. But everything regarding public policy of how they're using it against us is all that special administration of the estate. So anyway, so to continue, this can only be accomplished by each individual acting separately and independently using public laws for private purposes. The only way the individual can do this is to move out of the public charitable religious trust that is making the public policy and take back his estate into his absolute control. That's the point. And take back his estate into his absolute control. If you do not do this, you have no title. If you do not do this, you have no standing. And that's where everybody's missing the train here. So remember, public laws are laws that guarantee separation of powers, so private conscience laws, Roman civil law, cannot dictate public policy. All political action groups have failed to make any difference because their inability to recognize that our nation was established first and foremost as an assembly of individuals acting independently in their own best interest without harm to another. Basically, general common law. Right. Because we're the ones as the people who bring the adjudication and the punishment for violation of the general common law. And the general common law is whatever the fuck we feel like it is. Literally. If a grand jury gets together and says, you know what, we don't like what that corporation's doing. Or, you know what, this guy's gone batshit nuts and he's polluting the river unnecessarily. Or whatever it may be. Doesn't matter. They can write an indictment and indict whatever they want to as far as that general common law is concerned. So, with that, even if political action groups went so far as to foster a constitutional convention, the basic constitution could not be changed. What the citizen is unaware of is that the first 10 amendments to the Constitution, called the Bill of Rights, were passed as public, in-law amendments by the states of this union, known as the Republic of the United States of America. These do not apply to the several states, meaning the political subdivisions, the territories, the conquered territories, as they were, of the 14th Amendment Trust of the District of Columbia, called the Democracy. Right, so I know that was a lot of verbiage in there, but it's basically the separation of what was above in the chart. So, in the opposite vein, Amendments 11 through 25 were passed as private at-law amendments by the several states operating as political subdivisions of the trust and have no application to the Republic and its citizens. Amendments 11 through 25 function outside the Constitution. Any additional amendments that would be added by a Constitutional Convention would be added as more private law only by the several states as a democracy outside the Republic and its Constitution. The more amendments the democracy wants to add will not give more freedom and rights. On the contrary, only more oppression and control. Any special interest groups who says that the Constitution is going to be changed and or repudiated in the future does not understand what it is talking about. First, because the repudiation of the Constitution was started by the passing of the 14th Amendment in 1868 and completed by the people giving up their law, gold, in 1933 to move out from under the Republic and its absolute constitutional protected rights to parliamentary democracy. And second, because the basic constitution of the Republic can only be changed by the people of the Republic. Right? Not by 14th Amendment sheep. And there is nobody living there. Well, until we decide to re-inhabit it. But then we'd have to go find all the rest of us that are actually have gone back into the Republic and say, okay, now we're all getting together and saying, yeah, we're going to pass an amendment that say, I don't know, let's say abolishes the entire corporate government side. That'd be nice. Could do that. They need to have a legitimate de jure government literally saying, fuck you, and waging a war against a enormous multinational corporation. Sound familiar? Kind of like what the colonists did with the East India Trading Company. Yeah, same deal. And there's a whole connection with the East India Trading Company and the United States Federal Corporation, but I won't get into that right now. But to continue, the only changes to the Constitution that the 14th Amendment trusts democracy and its political interest groups can make as to the amendments that it made for itself and its citizens. That only comes with more control and oppression. As long as the people of the democracy continue to, I should say citizens, and I should say small c citizen, as long as a small c citizen of the democracy continues to function under the group mentally based on mob rule of opinion polls under the Roman civil law, more and more demands are put on the private commercial system. The more claims for benefits from the system, the greater the tyranny and oppression required to make the people perform to the debt and the interest on the debt that it created in order to supply the people's demands. It is the debt and its uncontrolled interest that is causing the production of the American worker a halt. He is being taxed in ever-increasing amounts and ways to try and pay for the national debt, which again is not ours, it's Congress's. He, meaning those people, has unknowingly and voluntarily demanded by his silence a silence that is financing his own destruction. Governments produce nothing. They can only take away. Why can't the people see the same thing as happening in the government today that happened in those 147 communist social experiments in the early days of our country? And yes, that's not a misprint. That's how many times communism was tried in little parts of America. Every single one of them failed. I wonder why. Yeah. The non-producers overwhelmed the producers to cause a total collapse of the commune. It is bizarre how the people of our nation sense something is drastically wrong, both politically and economically, and yet keep making all manner of beneficial claims. Now they are pushing for national health insurance, which, of course, this was written quite a while ago, so now that was Obamacare. The very cause of our national economic illness. It seems that no one can see the forest for the trees. No one can see that they must unequivocally stop all demands from the government and become self-sufficient at all costs. When individuals change their standing in law from 14th Amendment citizens dependent on the social insurance trust to non-14th Amendment citizens who are self-sufficient operating under the public law merchant, our nation will change and not before. Well said. Postscript. After having been exposed to most of the information from various factions of the patriot sector on how to get back our rights under the Constitution, none have ever addressed the real issue of law. Exactly. Well, except us. The groups that are claiming victories in their skirmishes with Big Brother are not winning on issues of law. Rather, their wins are nothing more than the result of technical knockouts. Their skills at discovering potential fouls of either rules or codes that govern the system they are an inmate part of is the measure of their success or failure. Even with a legal win under the 14th Amendment trust and its conscience, there is nothing to prevent the trust from institution new proceedings at a later date. It doesn't exist. It's not there. So, this is because the conscience of the trust is altered according to expediency, right? To just get it done. Everything is just grinding. The machine just grinds forward. They just stick in the meat grinder. Out you come on the other side. That's it. The real issues of law that are the foundation of our political system continue to evade the so-called patriot. And this is a quote here: if laws are to have a binding force, it follows that, in view of the right of self-consciousness, they must be universally known. To hang the laws so high that no citizen could read them, as Dionysius the tyrant did, is injustice, is one of the same kind, and can bury them in row upon row of learned tomes. Collections of dissenting judgments and opinions, records of customs, etc., and in a dead language too, so that knowledge of the law of the land is accessible only to those who have made it their professional study. Good point. So Hegel's comments are extremely appropriate for today, even though they were written in the last century. What has been discovered is comparable to a revisiting of the chambers where our founding fathers met in secret. They purposely disguised some of the language in terms that would not allow tampering and loss of basic issues of law that are the foundation of the Republic. Exactly. A foundation based in the common civil law without the private conscience of any church charitable organization. And this is kind of an oxymoron. I wouldn't ever say common civil law per se. I would just say common law, because civil law is always Roman civil law. So I wouldn't really ever use that particular combination of words there. But I understand what he's getting at. So yes, it's the people's fault, our fault, for allowing a complacency about our liberty to put us to sleep. In the beginning of our country, every household studied the law as much as they studied their Bibles. They came to appreciate knowing and using the law more than any modern-day attorney. However, gradually, the professional attorney at law dominated the political picture, and this led to our lawmakers being better informed in private law for commercial purposes because it was their specialty. Thus, our government and its vast majority of private at-law lawmakers turned its citizens into people who only knew what it was like to operate under private church law, controlling commercial public policy. In other words, Roman civil law garbage. This has given us a school system, both public and private, that is graduating students who have no idea what absolute freedoms of the Constitution mean. Right, the study of civics. That's why these Saturday classes at the Vocational Science of Freedom are called civics and sovereignty classes, because it's civics that they have stolen from you. And civics is the study of one's personal rights. That's the point. So students are born, bred and raised on the prejudice toward an old communal democracy being advertised as the new world order, where the state is sovereign, not the individual. From the historical records, it is evident that our forefathers knew at some point beyond their time the majority of people of this nation would get enticed and prejudiced into an economic jurisdiction that would become repugnant. The Constitution allowed those repugnant jurisdictions, but it also made provisions for one to walk away from them any time that they would individually choose. Knowing the law will allow one to do it, and that is what this treatise is all about. And that is the end of our reading. Now I can thumb through some of the footnotes here, but just so you know, all of the footnotes that are in this document, all of the numbers here, these little blue numbers, all the footnotes are in the bottom of the document, right? So I highly suggest for continued reading that everybody take a look at the footnotes, whether they be court cases, whether they be books to look into. Particularly this one is a very, very important one, Hale versus Henkel. This is the power of the grand jury, this particular case. And I covered Hale versus Henkel extensively in the grand jury classes that are posted onto the VSOF Odyssey page, and I'll just make a link into there in case anybody wants to know all of your power under the grand jury. And the grand jury classes there's 13 of them. I believe all of these actually go through a handbook, which was a grand jury report and also a grand jury manual from California. But what I do is I contrast what's in the grand jury manual, which is basically a Roman civil law suggestion guide for the sheep that they throw into grand jury duty, compared to what your actual power is. And so I cover Hale versus Henkel extensively in that particular class. And so I'm not going to go through the rest of these because we're coming up on time here, but But a lot of these cases are interesting and important, and make sure to go back and read the context of where they're labeled in the document. So again, this has been the reading of U.S.A. The Republic is the house that no one lives in. And I don't have a date for this thing. I just know that I found this document at least over a decade ago, probably longer. I think I found it in my late 20s, maybe even mid 20s. So it's been out for a long time. I haven't seen a lot of people talk about it, so that's why I wanted to make sure that everybody has this document and that they can go through these classes and understand the importance of what these people were talking about. So with that, I'd like to thank everyone for coming. This has been the Vocational Science Freedom Saturday Night Civics and Sovereignty class, and this is the last installment of this particular reading. For all of you, enjoy the rest of your weekend. Thanks for coming. And until I see you again, stay safe and stay sovereign.